With just 90 days until one of America's most powerful and controversial surveillance programs expires, the Trump administration has offered Congress nothing but silence. No position, no officials, no answers. At today's Senate Judiciary Committee hearing, Senator Chris Coons of Delaware, a seasoned Democrat and longtime advocate for civil liberties, demanded accountability from an administration that simply refused to show up.
Chairman Grassley, for holding this hearing today. Section 702 implicates some very foundational American liberties, and this is exactly the sort of oversight hearing and pre-action hearing that this committee ought to be having. I really appreciate you dedicating this time. And to our witnesses, thank you for being here. Section 702, as we all know, is a critical tool in the fight to keep Americans safe. Information collected through 702 has disrupted terrorist attacks on American soil, exposed foreign ransomware attacks on U.S. infrastructure, prevented weapons of mass destruction from reaching those who would use it to do harm. But Section 702 does not and should not give the government carte blanche to collect and search the communications of Americans in any way that it chooses. So I remain deeply concerned about the breadth of this program and its potential for infringement on Americans' constitutional rights. I voted against the reauthorizations of Section 702 in 2012 and 2018 because, in my view, at the time, those bills did not do enough to protect Americans' privacy. However, in 2024, I voted to approve a short 2-year extension because I was convinced that the reforms in that bill, like robust accountability procedures at the FBI and opening the doors of the FISA court to congressional oversight, could make a big difference. And today, I had hoped to hear from witnesses about whether those reforms have been appropriately implemented and whether they've been effective, but I can't ask those questions of officials from the government who are actually implementing those reforms because they're not here. No disrespect to the witnesses before me, but you're not the folks actually running these programs and implementing these reforms. We are 3 months from the expiration of Section 702, and the Trump administration, as best as I can discern, still has no official position on it. That is stunning. When then Chair Durbin of this committee held a hearing on Section 702 in June of 2023, a full year, nearly a full year before reauthorization, we heard directly from officials at the NSA, the CIA, ODNI, DOJ. I think it's unacceptable that with just 90 days, the administration doesn't know how it thinks about the program and has no one here to explain or defend it. If it's working well, why can't you tell us? Why can't you send someone to sit here and answer our questions about how the administration has reformed and improved this program to keep Americans safe without trampling constitutional rights? If you no longer support the program, why can't you tell us? Why can't you tell us what additional reforms we maybe should be considering to better protect privacy? Deciding whether or not to reauthorize 702 is a decision I take very seriously, and I owe it to my constituents, and I don't know right now which way I will ultimately vote because I don't know how this is being implemented. The Trump administration should be here to participate and answer some of the many excellent questions posed to this capable panel. Let me ask a few questions that are relevant, I believe, to your areas of practice and expertise. Ms. Goitein, could you just explain in plain terms how the expanded definition in RISA of Electronic Communication Service Provider, or ECSP, differs from the previous definition, the previous law,
right,
and what new surveillance capabilities it may actually create for the federal government, and what would an appropriately narrow ECSP definition look like in your view?
Sure. Thanks for the question. So this change in definition, as innocuous as it might seem, is what Senator Wyden referred to as one of the most dramatic and terrifying expansions of government surveillance authority in history. And unfortunately, he was not overstating the matter. The government conducts Section 702 with the compelled assistance of electronic communication service providers. Before RISA, these ECSPs, for short, were defined to include providers of actual communications services, such as Verizon and Gmail, that have direct access to Americans' communications. And the way it worked was that these companies would isolate and turn over the communications of the targets. RISA made a change, and the reason for that change was that in 2023, 2003, the FISA court ruled that FISA's definition of ECSP didn't include a particular type of provider, and that if the government wanted to include that provider, it would have to seek amendment of the law. That provider, we all found out through the New York Times, was a data center for cloud computing. This was confirmed by senators during floor debates. But even though it's now public knowledge, it remains officially classified, and so rather than actually seek an amendment to add data centers, the administration deliberately sought an amendment drafted in incredibly broad and vague terms to obscure the type of provider at issue. So under this new definition, the government can compel the assistance of any provider of any service, as long as that the provider or the employees or the custodians have access to equipment on which communications are routed or stored. Think about it. That's pretty much every business or organization in the country. There are some narrow exceptions in the definition, but almost every public-facing business organization provides a service, and they all have phones and computers. And because these types of businesses are not going to have the technical ability to isolate and turn over targets' communications, they may be forced to give the NSA direct access to their communications equipment with all of the purely domestic communications running through the equipment, and then the NSA is on the honor system to only pull out and retain the target's communications.
Do we know whether this has happened?
I certainly don't know whether it's happened. The Biden administration committed to only applying this definition to the type of provider at issue in that one case, and to reporting to Congress on its uses of the provision, not to make public reports. So that is one. If you haven't received these reports, I don't know that this administration is bound by the Biden administration's commitment, but that's a big problem, because the potential for abuse of giving the NSA direct access to the communications equipment of almost every business and organization in the country cannot be overstated.
I recall this debate. Mr. Klein, if you could briefly, do you think we need to revise this definition and narrow it?
Under the USA Freedom Act, and as elaborated by subsequent laws Congress has passed, the intelligence community is supposed to declassify novel or significant interpretations of law that come out of the FISA court. The Congress also should be receiving unredacted versions of those important FISA court opinions. So if there's a significant expansion in that term beyond what's expected, you all should know about it. Eventually the public should find out. But as for data centers, if a Russian general is putting his stuff on a data center in the United States, and we can get that to protect the American people and our allies, I think we should do it.
Senator Chris Coons, a thoughtful moderate Democrat who has spent over a decade wrestling with the tension between national security and civil liberties, came to that chamber with a simple request. Tell us how this program is working. Tell us whether the reforms we passed are being implemented. Tell us, quite frankly, whether you even want this authority to continue. The Trump administration's response? An empty chair. Let's be clear about what Section 702 is. This is not some obscure bureaucratic provision. This is the legal architecture that allows the United States government to conduct surveillance on foreign targets, but in doing so, inevitably sweeps up the communications of American citizens. It is a program that, in the wrong hands or without proper oversight, could transform from a shield against foreign adversaries into a sword pointed at the constitutional rights of the very people it claims to protect. And what did we learn today about how this administration is wielding that sword? Nothing, because they didn't bother to show up. Today, with just 90 days remaining, this administration has offered Congress and by extension the American people nothing but silence. No official position, no testimony, no accountability. Now, some might argue this is simply administrative disorganization, the chaos we've come to expect from this White House. An administration that refuses to articulate its position on a surveillance program of this magnitude is an administration that wants maximum flexibility with minimum oversight. And that should alarm every American, regardless of party. The testimony we did hear today was illuminating and deeply unsettling. Elizabeth Goitin of the Brennan Center laid bare what Senator Ron Wyden has called one of the most dramatic and terrifying expansions of government surveillance authority in history. Under the revised definition of electronic communication service provider, the government can now compel assistance from virtually any business or organization in America that has access to equipment through which communications pass. Think about that for a moment. Your local coffee shop with Wi-Fi, your doctor's office, your church, your child's school. Under this expanded definition, all of them could potentially be conscripted into the surveillance apparatus of the federal government. And because these entities lack the technical sophistication of a Verizon or a Google, they may have no choice but to give the NSA direct access to their systems, trusting the government on its honor to only collect what it's legally permitted to collect. The Biden administration, to its credit, committed to applying this definition narrowly and reporting to Congress on its use. But as Ms. Goitein pointedly noted, there is no guarantee, indeed, no indication that the current administration considers itself bound by that commitment. And if Congress hasn't received those reports, the silence from the executive branch takes on an even more ominous dimension. Senator Coons stated plainly that he does not know how he will vote on reauthorization. This is a man who voted against Section 702 twice on civil liberties grounds before supporting a reformed version in 2024. His uncertainty is not indecision, it is the responsible posture of a legislator who refuses to rubber stamp authorities he cannot verify are being used appropriately. The question now before Congress and before the American people is not simply whether Section 702 should be reauthorized. It is whether we are willing to accept an executive branch that operates critical national security programs in the shadows, beyond the reach of meaningful oversight, accountable to no one. If the Trump administration believes this program is vital to American security, they should defend it publicly. If they believe it requires modification, they should say so. If they intend to let it expire, the American people deserve to know.